joining us today. This is the New York Staff Union third session. Today, our session focuses on things that you need to know about the G4 visa. The presentation today will be made by David Gottfried, a New York State lawyer, experienced in providing U.S. immigration representation for foreign national individuals seeking non-immigrant visas and permanent residence and U.S. citizenship. David is here to answer only questions related to the current situation of G4 visas and current U.S. immigration law and policy. Please use the chat to post your questions and limit your questions only to U.S. law, policy, and how it affects you as a G4 visa holder. David is not here to answer any other question that relates to the UN internal procedures. Our moderators today for this session is Leonid Dolgopolov, OHCHR in Haiti, Ritu Sharma, Crisis Preparedness and Support Unit of DOS. Over to you, David. Thank you and welcome.
Thank you very much and good morning. I will solely be talking about G4 and immigration issues. I am not a tax professional, and so I will not be providing very much tax advice. I think you'll have another session on that topic. So my name is David Gottfried. As Narda said, I'm an immigration lawyer for 10 years. I was trained by my father, Robert Gottfried, who used to give the UN pre-retirement seminar starting in 1990, and he trained me well to be one of the knowledgeable people on this issue, as it is now becoming even more challenging with what's going on and the recent retrogression, which I will get into and explain, because there's a lot of misunderstanding on that topic. So I'm going to start with just the basics, the rundown on the specific G4 policies. I've been given a list of 50 questions to answer towards the end, which I will provide responses to. Narda, can you hear me? Hello?
I can hear you.
Okay.
Okay.
Somebody wrote that I was muted. So I will answer those questions towards the end, and then I will answer any additional questions that people have in the chat. I'll try to get to as many questions as we have time for. So I'm going to start off with retirement for international civil servants, the G4. So this is kind of the quintessential UN retirement that people talk about. And the requirements for that is that you hold a G4 visa status, not A or any other G1s, for instance. And you must have been physically present in the United States for at least 15 years before retirement. So this is where your duty station is the US. It doesn't have to be New York, but generally speaking, for the people in this presentation, I imagine it is New York. It could also be DC for like the World Bank. And out of that 15 years, you must have been physically present in the United States for 3.5 of the 7 years prior to applying for the immigrant visa or adjustment of status. And you must apply for that immigrant visa or adjustment of status within 6 months of retirement. So this is the first kind of thing I want to hit on, because it's a very misunderstood. So the immigrant visa is an I-360 petition. So this is a USCIS form I-360. And the sole point of the I-360 is that you qualify for what I had just written, that you spent the 15 years in G4 service. You send in that form with the, I think, $515 and the documents proving that you've been physically present in the US for 15 years in G4 status, and that will give you a priority date. And a priority date is where your turn in the waiting list is. This is not the same as adjustment of status or the green card. That is a separate process, which is I-485 form. That is the green card form. So initially, there's only the I-360 petition. Prior to December 2022, you could file the I-360 at the same time as you filed I-485 and additionally ask for work and travel authorization. Currently, you could only file the I-360 initially. So that is a really big misunderstanding on what's going on currently. And so if you retire, that would be the form you would file within the 6 months. It's the I-360 petition, and that would put you in the waiting list for to get your green card either from within the United States as adjustment of status or through your home consulate through what's called immigrant visa processing. Next slide. So the spouses of a retired G4 employee can also get their green cards. They must be married before the I-360 is approved, and they'll come along for the ride. Essentially, they just have to show that they were married before the I-360 is approved, and then they can get their green card at the same time that the principal G4 person gets their green card. Next slide. So then there's the children of UN employees. So if you have 5 kids, you need to file 5 I-360 petitions. You can't file one for multiple kids. That's the first bullet point, no derivatives. So you have to file an I-360 petition for each of your children. In order to qualify as a UN kid, you have to have 7 years of G4 status between the ages of 5 and 22. So it's the US government decided that it's the day before your 22nd birthday counts as 21 years old. So if you have that 7 years between 5 and 22, then you would be able to petition the I-360. And so that I-360 is the same thing that it is for the retiree. It's puts you in the waiting list for your child. And so what would happen is once your child met the 7-year requirement between ages of 5 and 22, you could file the I-360 for them, although technically they file it for themselves, and then that would put them in the waiting list until their turn in line to apply for the green card or to go through the U.S. consulate abroad for their green card. They would just be on the G4 like before. Nothing changes. They can't apply for a work permit. They can't apply for travel authorization. They have no special benefits or limitations or otherwise until it's their turn in the waiting list. So this is also kind of a misunderstanding of what's going on. So if, for instance, you applied for the I-360 and the I-485 after December 2022 and the I-485 was denied or rejected, the child just has the I-360 approved, they would just be in the waiting list on their G4 until it's their turn in line to actually apply for the green card. And so for that, you also need to have 3.5 of the previous 7 years in G4 status. Let me see. So to answer the question, you can have 15 years cumulative. It doesn't have to be continuous. And for the child, it can also be 7 years cumulative, but that's where that last bullet point comes in with the 3.5 of the previous 7. So if your duty station changed, you could still qualify. You just have to have that 3.5 of the previous 7 in the total amount. And then you must file the I-360 before the child turns 25. So you could potentially qualify at your 21st birthday turning into, or your 22nd birthday. Before then, you have to qualify, and then you would have this turn in line. So your child potentially could be much older at the time they actually get the green card. So I think the most important thing to note is that at the moment, you can only file 360s to get in the waiting list. Next slide. So this is kind of an unknown benefit to people. It's an end visa. Now, before the backlog, the retrogression, this was a lot more helpful, but there's still some people who can benefit from this, and it's not very well known. So if your child got their green card through the previous slide, which is the special immigrant juvenile child, then your duty station. So for instance, your child gets their green card as a UN kid, and then your duty, you get, the UN wants to transfer you, or you don't want to work for the UN anymore, but you want to stay in the US, you can change status to N. And so the N allows the parents and siblings to remain in the United States until that permanent resident child is 21. And they can also obtain employment authorization. So this can be a huge benefit to people who, let's say their child is 12, they get their green card at 14, 15, something like that. And then you still have all those years until they're 21 for the parent and siblings to remain in the US, have work authorization, be able to continue traveling back and forth. And it even allows for like a sibling, if they didn't meet the 7 years for their own green card, the end time counts towards their 7 years. So it aggregates towards their 7 years. I'm sorry, Carla, it does not apply to American children. So it is only a benefit is if your child gets this end visa as a child who obtained their permanent residence through the UN 7-year process, which was the previous slide. If your child is going to sponsor you for a green card, they must be 21 years of age and a US citizen. And so on a child's 21st birthday, they can sponsor their parents for permanent residence as a US citizen. Next slide. So here's the real thing. This is what there's so much confusion about. This is retrogression. So there have been no policy changes, no changes in law. Nothing actually changed as far as the US government goes when it comes to UN retirees or children. What happened is that for whatever reason, and there is no logical reason, UN retirees and children are in what's called employment-based fourth preference. And also in employment-based fourth preference for no discernible or logical reason are what's called special immigrant juveniles. So these are the orphaned and abandoned children applying for permanent residence based on that. And over the past several years, there's been a huge surge in people applying for special immigrant juvenile kids. And that has maximized the amount of green cards available in employment-based fourth preference. So if you read the slide, it says that there are approximately 10,000 visas per year designated as employment-based fourth preference. And they just get kind of first come, first serve allocation. And so if more than 10,000 people apply, they create a waiting list. And the problem with the waiting list is that we don't exactly know how fast it moves. The way to track the waiting list is the visa bulletin. And so the visa bulletin tells you where in the waiting list they're currently processing. And I believe the last time I checked the visa bulletin for employment-based fourth preference, now this bulletin gets updated once a month, and December's is already out. They updated, they provided about 15 days in advance. So employment-based fourth preference is currently allowing people who filed February 1st, 2021. So this is where the I-360 comes into play, is that locks in your priority date. And so if you have a priority date, meaning you filed your I-360 petition February 1st, 2021, it's now your turn to apply for the green card. For UN people, that's a bit misleading because if you had filed February 1st, 2021, you'd already have a green card by now. So it really affects the people starting about December 2022 going forward, because that's when the first visa bulletin indicated that there was a backlog. And so if there are no currently available green cards out of that 10,000, then you cannot apply for your green card at the same time that you apply for the I-360 petition. This is where this long wait list is, and no one really knows how long it's going to be. For young children, it doesn't really matter as long as it happens like before they're 18, ideally, then they can be like permanent residents and get in-state tuition or financial aid for college or something like that. But for a retiree, this is a huge problem, because now you cannot apply for a green card, which means you cannot get a work or travel benefit upon retirement. And so this creates a big problem, because the UN tells you have 60 days post-retirement to depart the country. And so some of your colleagues have reached out to me in this circumstance, and don't have anywhere to go. Well, the US is their home. They've been here for 20, 30 years, and they cannot apply for their green card initially. They can only apply for the I-360 to get in the waiting list, and it's kind of an unknown period of time for how long that wait list will be. So there are some options. You could apply to change status from G4 to a different non-immigrant status. For instance, one of your colleagues is doing an E2 visa, which is a treaty investor visa, starting their own business that leads to the employment of American workers, which is just one example of being at the one hand applying for the I-360, and on the other hand getting a different non-immigrant status to stay in the United States while waiting for their turn in line. There are also other ways of getting your green card, and as noted on my slide, if you have a U.S. citizen spouse or child over 21, you should definitely go that route instead of thinking about the UN retiree route, because U.S. citizen spouse or child over 21 is an immediate relative. There's no backlog. There can't be a backlog. And so you can you get your green card significantly faster and easier. And you could also concurrently file the family-based petition with the adjustment of status. Some of your colleagues have applied for employment-based first preference, which is extraordinary ability. So extraordinary ability is if you've risen to the very top of your field, and there's 10 criteria for that. And if you meet 3 of those 10 criteria, just examples are: have you been interviewed about your work in major media or publications? Have you won awards for your work? Have you been a member of an organization that requires outstanding achievement? Have you published in known journals and periodicals and whatnot? Have you been a lead role for an organization with a distinguished reputation? So this would be a way to self-sponsor for employment-based first preference. And as long as you weren't born in India or China, you'd immediately be able to apply for your green card with that case. Unfortunately, employment-based second preference also has a wait list, although significantly shorter than the employment-based fourth preference. So employment-based second preference is currently allowing people who filed August 1st, 2023 to apply for their green cards. And there is a way to self-sponsor for employment-based second preference. It's called national interest waiver. So the national interest waiver is that you have this projected project, career that will benefit the United States. I can get into that more on a more individualized basis, but just to give a quick overview, it's they really like STEM fields, tech, and those kinds of things. But I have been successful in helping your colleagues in policy areas, environmental, and some other areas. So those are kind of the employment-based routes. For permanent residents is first and second preference. And of course, there's family preference cases, immediate relative. There are other family ways to go, like your parent can sponsor you or your sibling can sponsor you, but those have extended wait periods as well. So for instance, a sibling case, they're currently allowing people whose sibling filed for them March 1st, 2008 to get their green card. And your parent case, if you're unmarried and your parent is a citizen, that would be 2017. If you are married, then it would be April 2012. So this is not exactly a fast benefit, and potentially not even a worthwhile option depending on your situation. I think that kind of covers just the overview of the circumstances. I'm going to start answering the questions that were previously submitted to answer those to everybody, and then I will try to answer the questions in the chat box. So I tried to take out some of the questions that I thought I already answered. So if I don't get to you at the end, and if it's not tax related, then please feel free in the chat box. So the first question is, I will be retiring in 2 years. When should I start the process to apply for a green card? And when is the earliest you could apply? So as a UN retiree, the I-360, you can only apply after you are retired. One of the requirements for that is providing a letter from HR that says you have actually retired. Not that you are going to retire or that you will retire or that you're on special leave, but actually retired. I've seen the USCIS be very strict on this issue. So for that, you could only apply after you are actually retired. You could apply the day you retire for the I-360. For a family-based case, it's a little trickier. So if your spouse or child is sponsoring you for a green card, theoretically, you could apply at any time. There is no deadline or limitation on when you can apply for that permanent residence. I'd say the main factors to consider for that are, once you are a permanent resident, you will be taxable on your income or pension, although not a lump sum pension. And then the other aspect is once you do apply for a green card, which is I-485, you cannot leave the United States without advance parole or your green card at that point. So people call me all the time, I have a child sponsoring me or my spouse. I want to get a head start on it. And the first thing I ask them is, do you have any international travel planned? Because if you do, you should wait until you don't have any international travel planned before applying for your green card, as to not interfere with your green card case. Because if you leave the United States without advance parole or your green card, you will abandon your case. And then you will have wasted your time, effort, and money. So if you didn't have any travel plans, you could apply for your marriage or child-based green card case at any time, and probably some months before you retire, just to get a head start on the process. At the moment, family-based cases are taking about a year, but who knows if that'll stay the same. That fluctuates fairly consistently, even without the incoming administration. And at least if 4 years ago was any indication, one of the things that happened was that the previous administration liked to interview all cases that were possible. So all employment-based cases, all family-based cases, while the current administration was focusing on interviewing citizenship cases as a priority. So I have been to an interview with a UN retiree who was married for 30 years to their US citizen spouse and had adult children. We went to that interview. It lasted about 5 minutes, and the officer was more interested in talking to the people about their experience at the UN than they were about their marriage. But there's only so many slots available at these offices. There's only so many employees. And so that in and of itself could delay how long it takes you to get your green card. So instead of waiving the interview for a marriage green card, they would, create this extra requirement of an interview, which would delay things. Currently, advanced parole is taking like 3 to 9 months, but that again is a bit all over the place. And so there's really no specific time on when to apply for a family-based green card. It's kind of a more person-specific answer. The next question is, why wouldn't the UN sponsor G4 visas for parents? We want their support by having them. I don't have an answer for that. I'm sorry, that's a UN or US mission type answer. So another question is, how long after your contract expires your G4 visa be valid? So this is another common misunderstanding. Because you as G4 holders get your G4 renewals within the United States, I've often seen there be a misunderstanding between a visa and a status. So a visa is that sticker in your passport. And for everyone other than G visa holders and A visa holders, you would get that sticker at your home consulate. And so that sticker visa only allows you to enter the United States. Once you enter the United States, it's your status that controls. And so if you remember back in the day when you'd fly in, they'd give you that little white card. That was called an I-94. I-94s are still available. They're just digital. So if you Google I-94, you could put in your passport number and your name and birth date, and it'll spit out your I-94 number and how long you're allowed to stay. And on a G4, you're allowed to stay D/S, duration of status. And so that is essentially, there is no expiration date on your status. And so while the UN tells you that you have 60 days to depart the US after your contract ends, in the US, what me as an immigration lawyer is concerned about is unlawful presence. And so unlawful presence is if you came as a tourist and were given 6 months. Well, on 181st day, you would start gaining unlawful presence. And if you have more than 3 years of 6 months of unlawful presence and left the United States, you would have a 3-year bar. If you had more than 1 year of unlawful presence and left the United States, you would have a 10-year bar from coming back. But a G4 has no unlawful presence because it has no expiration date. So even if your G4 visa was canceled or expired, your status in the US would remain G4. And so this is going back to what I previously said, is if your green card case was rejected or denied for your kid because you filed it when there were no green cards available, it automatically reverts back to that G4, which did not expire. And so that's the main difference between a visa and a status. The status is what you have in the United States. The visa is that sticker, which only really lets you enter the United States. So if you were on a student visa, you would get that at your home consulate. You come to the US, and then if you did 4 years of undergrad and 2 years of master's and 3 years of PhD, you would have never actually had to leave the United States to change your status, because it would have been F1 student the entire time. Just like your G4, technically you wouldn't have to leave, for 20 years if you wanted, because your G4 would remain that whole time. And so that's something to keep in mind for some people who have decided that they don't want to depart the United States after they retire. They want to stay even in this kind of quasi status because that's what makes the most sense for them. And so they can file the I-360 petition, get in the waiting list, stay in the United States, and then ask for their green card interview to be at their home consulate. And so even if that was 3 or 5 years later, they would not have any penalty for overstaying. They would leave to go to their consular appointment, get their green card interview, and then return to the United States as permanent residents. I understand this sounds pretty odd and not proper, and I get that, but desperate times call for desperate measures at times. And while the UN is not going to tell you this, and the State Department's certainly not going to tell you this, realistically, it could work. It's not an ideal situation by any stretch, and there are some states that are very unpleasant to deal with if you don't have the right paperwork. Like you can't get a driver's license in Florida if you don't have a valid visa or work permit type of thing. But in New York, you can get a driver's license without showing your immigration status, for instance. So that's just kind of an example. Let me go to the next one. So somebody asked about delays for I-365 applicants. I think they meant I-485 applicants. So if you happen to have filed your green card case before December 2022 and your case is still pending, I have lots of clients in that spot, and it's a very annoying spot because essentially they're waiting for that priority date to become current to approve the green card. So that's where that February 1st, 2021 date comes from. And so those people can renew their work permits and travel permits while waiting for their green card to be issued. But it's still unpleasant when if you had applied 6 months earlier, you would have gotten your green card with no problem. It's just kind of the way it is. I do have several clients who initially applied for their green cards before December 2022 and also have U.S. Children or spouses. And I've tried very hard to convert their cases from employment-based to family-based. And 2 years later, we're still going through the process to the point where some people have suggested just withdrawing their employment-based green card and starting all over again through the family to try to go through that normal process and time frame. It's been a very frustrating process for all of you, but also me with this retrogression. This has never really happened before. So I don't really want to get into taxes too much, but somebody asked about passive income on stocks, crypto, dividends, CDs, and can you invest in the stock market? Yes, you have to pay taxes on that. And yes, you can invest in the stock market on a G4. So to answer those questions, yes, you would be required to pay taxes, and you could invest in the stock market. You could also open a business, but theoretically you couldn't work for that business. So in terms of filing an application for a green card, the processing time from within the United States is about 1 year. If you go through your home consulate, it's going to be 18 months minimum. And then it's somewhat dependent on which consulate you go to. So for instance, Dhaka or Islamabad, that's going to be like 2 years, maybe longer. They're just very slow. I also am the previous administration kind of reduced the amount of employees at U.S. embassies and consulates abroad. So if that happens again, that would increase the wait time for appointments at those consulates because there wouldn't be enough staff to interview people. Generally speaking, people want to adjust status or get their green card from within the United States if they can versus going through a consulate. But Some people, it makes more sense for them to go through the consulate because then they don't have that limitation on traveling. Can my dependent go to work with the G4 status? I'm fairly certain kids can get work permits through the UN, right? Aren't you allowed to get a work permit as a UN kid until you're like 21 or something? In case of the death of the principal G4 visa holder, what happens to the dependents? Unfortunately, they have 60 days to depart the United States. There's no special rules for that. The U.S. government doesn't have any. If the person had the 15 years, the spouse could benefit from that and apply for the I-360 petition. But otherwise, there's no like U.S. special rule for that. Can you hold 2 U.S. visas such as student G4? Technically, you can have multiple visas in your passport, but there is a State Department regulation that says if you are entitled to a G4 status, then you must be in G4 status. So I've had this question come up many times over the years. Someone gets a job at the UN and their spouse is on an H-1B visa or an L-1 visa or something like that. That is not allowed. If you are in the same household as someone, they must be also on the G4 visa. The exception being is if you're not in the same household. So if your child goes away to school, they could be on an F1 student visa. And the benefit to that is if you're on an F1 student visa for at least 1 year and graduate, you can get optional practical training when you graduate. So I've given this advice to many people because I've had people come to me, their child's graduating from college, they have no ability to work, and it's a very sad situation because it's difficult for a company to sponsor you for an H-1B visa, for instance, if they don't have any experience working with you. And so this is where optional practical training comes in, is if you have that 1 year in F1 status. So what you would do is you would transfer your child's, change your child's status from G4 to F1. Let's say their senior year, they should speak to their foreign student advisor at the school to make sure all the paperwork is correct for that. Transfer them to F1, and then they graduate. They can get 1 year of optional practical training, which is work authorization. Or if they're a STEM major, they can get 3 years of optional practical training after they graduate. And this at least lets your child open the door to having a job in the US, making those connections, having opportunity for a company to sponsor you for a different non-immigrant visa like an H-1B, and just kind of be in the United States in a functioning capacity. Because it's very sad that the kid turns 25 or they're 25 and they've been on G4 their whole life and they have never worked or an ability to work. It's really limiting. So that's kind of a good tip, is if you're not going to be able to get your green card ahead of that time, or if you're in the I-360 waiting list, if you get that optional practical training, it'll give you a little extra time. And then to go along with that, as I said, those STEM majors get the extra time, and that's based on what your major is. And so another small piece of advice is there are a lot of different STEM options. And so if your child's at all interested in some kind of STEM field, a lot of schools, it's only a handful more classes to be a dual major. And so the difference would be 1 year of training versus 3 years of training because you took an extra 4 classes in math or something. That might be well worth it. Let me go to the next question here. I think I answered that question. I think I answered that question.
David, there's
Yes.
also, I know you're looking at the list, but we also have in the chat, in the Q&A, current questions that may also be different than what you have as well.
Yeah, I was
Alright.
just going to finish the list
Alright.
questions before
Okay.
hitting the chat
All
questions.
right, cool. Thank you.
I'm almost at the specific questions. So if I win the DV lottery, which is a diversity lottery, will my conversion to G4 to green card be accepted? Yeah, you could win the diversity lottery and get a green card. I know there used to be some positions within the UN that if you became a permanent resident, you could no longer work at the UN. So that is something to keep in mind. If a staff member gives up their green card for G4, will it impact their green card application in the future? The answer is no. I've worked with several people who've given up their green card and then reapplied later on. Staff members in the US and G4, spouse is in another country but has ESTA. So this is what I came back to earlier. If you're entitled to G4, you're supposed to be on G4. So at that point, you would not technically be eligible for ESTA entry, which is the visa waiver program. Also, the ESTA is only 90 days and a G4 doesn't expire. And a G4 interview at a consulate should be fairly straightforward and easy. So I would suggest just getting the G4 to avoid any kind of problems. I have an approved I-140 category EB2 and my priority date is now current. Can I transition to green card? Yeah, I've filed for green cards for many people, family-based, employment-based. There's no issue with that. You can adjust your status either as a principal or as a spouse, because there's no rule that says a spouse can't be on a green card while the principal person is working for the UN on G4. So I want to know if your family gets a green card or citizenship, do you have to report to the UN? So as part of the green card process, you have to file form I-566 and I-508, and USCIS would then send those to the US mission to notify them that they are no longer on G4. So that they would automatically essentially be sent to the US mission to take you off the G4, and so that would solve your problem. So I think I answered this question. Is there, your daughter wants to file a petition for you? Is there a mandatory time for that? I believe I answered that question. There isn't really a mandatory time, and it's not a problem that you previously had a green card. Can a company sponsor my husband to get a green card while going through while being on a G4? Yes, there's no problems with that. Once they're filing for adjustment of status, they also can't travel internationally while waiting for their advanced parole or green card. I think I answered that question. Optional practice training. Okay, I will start looking at these chat questions. Let me see if I start at the back here. This is going to be a challenge. So I will retire April 2025. G4 is valid. Will the visa be canceled? As part of your P18 exit process, I believe they cancel your visa. So, but once you're retired, the visa is irrelevant because, as I said, the visa only lets you enter the United States. And if you tried using that after you retired, that'd be fraud. So that would be a really bad idea. Staff, family. Not sure how to answer this question, Tarig, about non-family duty stations. Unfortunately, it's either the green card kid or the N visa, depending on your circumstance. The U.S. just doesn't have a lot of options or very many options. I mean, people can be on an F1 student visa in the United States. As a kid, even at like a private school or public school, a child could be on an F1, but it's not an ideal circumstance, certainly. So I think I explained this question about the freeze. Technically, there's not a freeze. Technically, there's just an overuse of the employment-based fourth preference. So I had answered this question: 15 years continuous or cumulative. It's total, it's cumulative. So to answer David Marshall's question, it's these special immigrant juveniles. It's these orphan and abandoned kids. As far as how long it'll take, nobody knows. This has been the visa bulletin is a great mystery. It goes forward, it goes backwards, it stays the same. No one really knows. It's just not logical that these orphan and abandoned kids are in the same category as religious workers and UN people. It just doesn't make any sense. But I know a bunch of the organizations are trying to get the government to change that. Maybe it'll happen. I don't know. Answer that question. So for dependent children, so the petitioner be the child if only 13 years old. So technically the I-360 would still be filed by the child, but there's a cutoff for signature. I believe if the child is below 14, the parent can sign for the child. I mean, immigration doesn't know what your child's signature looks like, so it doesn't, as long as the signatures are consistent on the forms. It used to be when you would file your case with your adjustment status, there was the medical exam, and I had a few cases where the parent signed the medical exam for the kid, but then the kid signed the forms, and then the government came back and said the signatures don't match. But these days, you would only file the I-360 petition, so it wouldn't. Whoever signs it, as long as it's the kid's name, it doesn't really matter. Yeah, so if you had a green card before accepting your G4 job and you gave it up, it doesn't help you at all getting another green card. You're just like everybody else. Your best option is to go through your children who could petition for you. Narda, do you know the answer about the G4 kids getting work authorizations? I thought there was
anything internal, no. So anything that has to do with our internal procedures, we don't have an answer for that.
Yeah, I thought there was I know the spouses can get work permits. I thought there was something about the children also, but I'm not totally sure.
They can get a work permit. My daughter got one when she was I think 16 or 18.
Yes,
that's
we
what I
can.
thought.
But first you
we
have to
can.
get a job offer to submit your application with.
Right. That's the same thing for spouses. You have to get this letter saying you have a job offer, which is not required for like any other work permits. I don't know who actually requires that, if it's USCIS or just the US mission. But yeah, I thought there were work permits for kids. This question from Adis about traveling outside once you're I-45. I think I answered that with the advanced parole. Richard, it is definitely faster to apply through your son than it is retirement, because the retirement thing has this huge backlog. The difference between spouses and kids is essentially the same at the moment. They're generally not interviewing spouse cases right now, but if that changes in the future, even 4 or 5 years ago, they weren't really interviewing parent to citizen cases. So if they're not going to interview that and they are going to interview spouse cases, then the child would be faster. Let's see. So you can apply for your child's I-360 petition before they meet the 7-year requirement. You have to wait for the 7 years in G4 between the ages of 5 and the day before your 22nd birthday to apply for the I-360. You cannot put them on the wait list earlier. To answer your question, Afsana, I believe what you're asking is if the first child already applied for the green card and waiting for their green card, but they haven't yet been approved for it, can their sibling get on the N visa? And the answer is no. The first child would have to have the green card in hand for the sibling and family members to go on the N visa. So to answer Faiza's question, you can actually do a change of status from G4 to N visa from within the United States. It's not always the easiest way to go or straightforward, but I have successfully transferred people from G4 to N from within the United States. The issue comes back a little bit with the timing because, as I said, if you're entitled to G4, you must be in G4. So it would have to be done either after the principal G4 left the United States or their contract was terminated, and then therefore the family is no longer entitled to G4. Then you could do a change of status to N visa. So to answer your question, Afsana, again, you could file for an adjustment of status with an approved I-360 and your priority date is current, even if you are no longer in the United States or if you are no longer in G4. So the I-360 petition holds regardless if your child is still in the United States or even as a retiree, still in the United States or in G4 status. So once you have the priority date, the I-360, you're still eligible whenever it is your turn in line, regardless of the other circumstances. So to answer your question, Kieran, annual leave counts towards the 15 years. It's not physical presence. It's essentially your duty station. So there were cases where like a kid goes to college abroad and they wouldn't count it towards the 7 years for a kid. And while you do have to submit as part of your I-360 petition as a retiree your travel history for the last 15 years, which is obnoxious, as long as your duty station remained the U.S., all of that time would count towards your time of the 15 years anyway. So I don't really know why they asked for it. They should just ask if you had any duty station changes. So your annual leave of 1 month would count towards the 15 years. So to answer Cyrilla's questions about the wait list is just a wait list. You get no benefit from being on the I-360 wait list. It's just like anybody else. You'd have to be on a G4 or some other non-immigrant status or outside the United States waiting. Having filed the I-360 gets you no benefit and no consequence. It doesn't affect your ability to get a tourist visa or anything else. And technically, when they ask you when you apply for a tourist visa, has anyone filed a petition for you? You could say yes, but that doesn't in and of itself prevent you from getting a tourist visa. You can apply for a marriage-based green card while still holding G4 status. So to answer the question, Niraj, about your child's, they could stay on G4. They wouldn't. So this is kind of part of the problem with the timing of these things. So in order to adjust status, you must have a current valid status. And so after you age out of G4 or retire from G4, while you don't have unlawful presence, what I discussed before, where there's no penalty for staying, you're still not eligible to get your green card from within the United States. So at that point, you would have to get your green card from the consulate abroad, which I think is part of the reason why some people are not necessarily the tourist, but if there was some other interest of yours, teaching at a university or starting a business or something like that, you could change to another non-immigrant status while waiting for your turn for the green card. And then if you maintain that through the time when it was your turn, you could apply from within the United States. But if you're like one of my clients who is just kind of laying low until it's their turn, unfortunately, they're going to have to go back to their home consulate when it's their turn to get the green card. And on the I-360 petition, you would note that you wish to go through the consulate to get your green card and not adjust from within the United States, because that would just create you having to file another form and to forward the case to the National Visa Center instead of adjusting from within the United States. So to answer Carla's question about if you have children who are younger than 21, unfortunately, the U.S. government, it's 21. This is part of this, they don't want people to come to America and have kids, and then that's the basis for them to stay. So they made it 21 years to kind of discourage that behavior. Yeah, so Fernando, you also filed the I-45 and got advanced parole, and your G4 was removed, but one of these days your case is going to get rejected and returned to you. I'm surprised it hasn't already, but that I-45 is not going to work in the long run. So once the I-45 is denied, the advanced parole will be denied, and your child will have to revert back and get another G4 visa. It's just the way it is. I had several clients, even in the early part of 2023, who purposely applied for adjustment of status when they knew they weren't qualified, just to see what would happen. And eventually they all got rejected and returned and hopefully refunded, although I have heard cases where the government just keeps the people's money. Audrey, I'd be happy to talk to you about fees on a more direct call. I don't feel comfortable talking fees at a big group like this. Every case is different, and I don't need to get into that. So Richard, I think I answered your question about waiting until retirement or not. There's no, it's just kind of whatever makes the most sense for your situation as far as your ability to travel and whatnot. So if you're a U.S. citizen, you could sponsor your parent for a green card, Diana. You have to be a U.S. citizen over 21 to sponsor your parent for a green card, and there's no restriction on that. I actually just recently had a case where the woman sponsored her mom for citizenship, and she was a member of the Communist Party because she was a teacher, and they would have taken away her pension if she didn't join the party or remain in the party, and they gave her green card anyway. So As far as new U.S. policies, Trump just put this guy Miller in charge, or not necessarily in charge, but he made him a deputy policy director. And Stephen Miller is super anti-immigration. He has been for a very long time, but there still is a difference between what the president can do unilaterally and what laws need to be changed. And so, even though Trump is going to be president and potentially has the Senate and House, they don't have 60 votes in the Senate. And so I don't think they're going to be able to pass any actual laws as far as immigration goes, to change like major issues. It would only be on the more limited side of what can be done without changing the law. And then, of course, the courts can fight back if there are attempts to change policy improperly. So I think, unfortunately, that there might be another Muslim ban. I don't know. That would not affect you if you were on a G4, because they can't deny your entrance on a G4. But I have a potential client who wants to sponsor her Syrian spouse, and not sure how well that's going to go, or how long that's going to take, because if they bar people from Syria from entering the United States, then it might take some years or a new administration for her spouse to come to the U.S. Other than that, there's a lot of smoke out there, but no one really knows what he's capable of, or what he actually wants to do, and what he's just talking about, because even his own companies use like the immigration system. You can look it up. His golf courses hire H-2B employees. His friends hire J-1 au pairs. His friends' companies use lots of H-1B people. So, him saying it on the campaign trail and him actually doing it are two different things. So, Oliver, to answer your question about detailed list, technically when you file the I-360 as a UN retiree, they do ask for a list of your travels. I usually just tell clients to do the best they can, because as I said, all of that time counts towards your 15 years anyway. So just do the best you can. I know the UN at some point was keeping personal action reports for required travel. So that might help you create your 15-year trip. And then, of course, your passports and whatnot. So Shannon, is the pension lump sum subject to taxes? If you're still in process of obtaining your green card and you haven't gotten your green card yet, and you have gotten your lump sum, it's not taxable. Lump sum counts as foreign income. So advanced parole can take like 6 to 9 months, or 3 to 9 months. It's kind of all over the place. They're not consistent with these things. Oddly enough, if you apply for the work permit and the travel permit, sometimes it comes as a combo card where the EAD has advanced parole listed on the bottom of it. And if that happens, the work permits are coming consistently in around 3 months. But if it doesn't come together and there's no understanding why it does sometimes and why it doesn't, then it could take many more months for the advanced parole to come separately, and it comes as a green piece of paper with your picture on it. So I wish I had a more definitive answer for you, but they're not consistent with the advanced parole. So if you have an approved I-360, it does not have an expiration date. It's just a matter of once your turn in line comes, then you would act on it either by being in the United States in status and adjusting status, or going through your home consulate with the National Visa Center. So technically, if the National Visa Center contacted you that your priority date is current, you would have 1 year to pay the fees and work through and communicate that you want to go through that process with them. Otherwise, they would close your National Visa Center case. But technically, that's not the same thing as the petition expiring. So the administration is not going to affect green card through kids or green card through spouses. That's changing laws. That's not going to happen. I believe the staff union is going to do another lecture on tax issues, so I will leave that to them. So Rosario Javier, you do not need to leave the country if your child sponsors you for a green card. I had a client, she entered the US as a tourist, gave birth, and then 21 years later, her child sponsored her for a green card. Never left the country. They still gave her green card. So no, you do not need to leave if you're an immediate relative, which is a US citizen child over 21 or the spouse of a US citizen. So a permanent resident child cannot petition a parent. There is no category of parent of a permanent resident. There's only parent of a citizen. Shantanu, yes, a spouse can be sponsored by the child while the principal continues with the UN. I've done that case many times. So Vandana, again, you can only file the I-360 once you're retired. You can still work for the UN while waiting for your green card on the G4. And then depending on how you were hired with the UN, whether you were, I think it's a local hire or a foreign hire or what level you are, you can continue working for the UN with your green card. It's not the United States that says you can't work for the UN as a permanent resident. It's the UN that says you can't work for them unless you're on a G4, depending on your circumstances. So that would be something you would want to check with HR ahead of getting your green card. Lucy, can a U.S. citizen child living abroad file for you? Yes. A child abroad can still file for you to get your green card. I mean, there's some complications with the affidavit of support and domicile, but it's definitely doable. I think I already answered Alex's question about employment. Richard, 60 days to leave. Yeah, you could return on a tourist visa. The thing to think about when you come back, when you apply for a tourist visa is when you apply for a tourist visa at your home consulate, one of the requirements is that you show you have a home you don't intend to abandon. And if you've just spent the last 20 years in the United States, it might be a challenge for you to prove to the consulate that you have a home you don't intend to abandon. So that is something to keep in mind when applying for a tourist visa. Also, something to keep in mind is if you're entitled to ESTA, the visa waiver program, and you decide you want more than 90 days and apply for a tourist visa, if the tourist visa is denied, your ESTA is also permanently denied. So if you're entitled to the 90 days, you should have a pretty good reason for wanting more than the 90 days. Because that has happened to more than one person where they're like, oh, I just wanted to stay for 4 months. So I applied for the tourist visa, and then they said no for the tourist visa for whatever reason. And they do not need an actual reason to deny you for a tourist visa. They can deny you for any reason or no reason. And then they try to go back to their ESTA and they're out of luck. So, Katerina, as far as the EAD through the UN, I believe it does have limitations. I'm not totally sure what those limitations are, but I do believe that they have some limitations on self-employment. You should talk to, I guess, the HR about that. So Martin, as far as the spouse's G4, I think they designate principal G4 and dependent G4, but in practical terms, I don't think it makes any difference. No, I answered that question. So, Muhammad, as far as the child reached 23 and still on the wait list, technically they don't have to leave the country, but you know, what does that look like for them? They're here, they're not working, they're just sitting around all day. I mean, maybe that's not the best circumstance, but technically they could stay. I had one of your colleagues years ago before the retrogression. She retired, got her green card, and then sponsored her son, who was disabled, for his green card. And there was I forget, like a 5-year waiting list for him to get his green card out of Manila. And he was a bit disabled. And so he wasn't working. And so he just stayed in the United States on G4 until it was his turn to go to Manila for his green card. And that's exactly what he did. Unfortunately, COVID then happened. And what would have been a like 2-week interview process turned into like a 6-month interview process, but no one knew. But that's what ended up happening. She became a permanent resident, sponsored her unmarried child, waited the time out. Then he went to Manila and they gave him his green card. Sanja, spouses can get a G4 upon marriage. I believe the UN requires the first G4 to be issued at the consulate abroad. So that would be a trip to your local consulate for visa stamping. I'm sure you can get that done in a few weeks. So, Rolf, I apologize in advance if I mispronounce your name. Ropafadazo, can the spouse and children still apply for an EAD? So the work permit is only given when you apply for adjustment of status. So if you're just in the I-360 waiting list, you can't apply for adjustment of status. So you get no benefits from just applying for the I-360. Nancy, I don't see any reason why you can't win the lottery on a G4. You would have to pay U.S. and New York taxes, but I don't think there's a requirement that you're a U.S. national to apply, play the lottery. As far as how long the I-360 process takes, not a long time, but in reality, at the moment, it doesn't really matter how long it takes because you can't get your green card right away anyway. So probably less than a year, but once you file it, it locks in your priority date. So that's the important part. Link to indefinite G4. So the indefinite G4 is your I-94. So if you Google I-94 and put in your name, birth date, and passport number, you'll come up with your I-94 information. And under how long you're allowed to stay, it'll say D/S. Gloria, can I take remote employment outside the U.S. while wait list for the green card and work authorization? That's kind of a gray area. Yeah, I think you'd be fine with that. So Alvin, your brother's a citizen. Yeah, I mean the brother thing is like 15 years. The parent thing for a permanent resident actually is faster than as a depending on if you're married or not. If you're married, you're a permanent resident parent can't sponsor a married child, but a non-married child of a permanent resident is currently working on 2017, and then a citizen parent of a child, unmarried child, is 2017 as well. But then if you're married of a citizen, it's 2012. But then sibling is 2008. So there's no fastest. Unfortunately, those are all very slow. So as far as 60 days or 30 days, so you must file the I-360 petition within 6 months of retirement. I know the UN tells you you have, I think it's 60 days to file the I-360 petition, but this is a misunderstanding. The UN wants you to file the I-360 petition within 60 days, but USCIS, who processes these things, says you have 6 months. So I have actually filed people before the backlog, the retrogression for their I-360 petition and green card at like the 5+ month, and that works. So Marina, you have to have 15 years of service with your duty station being in the US to apply for the I-360. Can a G4 spouse work for a foreign company remotely on a work permit? Sure. I mean, that's not a problem. I think I answered that question. How soon the spouse who are in their PhD program on a student visa should get the G4? So Sanja, according to the State Department, if you're married and living in the same household as someone on G4, then you're required to also be on G4. There's not a grace period on that. That's what the State Department wants, is if you're entitled to G4, you're on G4. I think I answered this question from Shannon. Your family could sponsor you for a petition even if they're not residing in the U.S. or even if you're not residing in the U.S. There are definitely ways to go about that. I don't know the answer to this, Daira Diaz. I'm sorry. I think I answered that. Oh, wait a minute. I lost my spot. Here it is. So Juan Carlos changed the status from EB2 visa. There's no restriction. You can apply for adjustment of status from G4 to EB2 if your priority date is current, because as I said, there's a backlog on those as well. Yeah, I'm sorry, M virus. I have heard that before, that the work permit takes a while. There is a discussion coming up, I believe, for you be able to pay extra to premium process work permits. That I'm not sure if that's going to affect UN spouse work permits or not, but I have heard that before, that the process takes so long that employers aren't happy with that work permit. And then it's kind of a hassle to get the work permit through the UN. So Nina, to answer your question, it's a gray area. Legally remain. Essentially, there's no penalty for remaining. You know, if Trump actually starts, bringing the army in to go house to house looking for people, then yeah, I mean, they if they found you, they would say you're not supposed to be here. But as far as you being here, there's no penalty for overstaying, and it's not possible for him to go house to house looking for people. And even if there was a list to deport people, you really wouldn't be on it because the U.S. is just not connected enough to understand when people retire from the UN and are no longer entitled to their G status. So they're really, you wouldn't even really be on a list. I answered that. UN staff able to pursue academic studies. Yeah, you can go to school while you're on a G4. I don't, Decky, I don't think G4s get student loans because at least government student loans. I mean, there are private loans, but you wouldn't be able to get like a government loan on G4. Those are, I don't think those are allowable for foreign nationals. So, do I know why UN agency requires you to relinquish your permanent resident and have a G4? I think it has to do with there's a quota for certain jobs that they have to be foreign hired. And so if you're foreign hired, then that job has to go to a foreigner. And if you're a permanent resident, then you're not a foreigner. I believe that's why they make you give up the green card to go on the G4, is that there's certain jobs that are listed as only foreigners can take them and not local people. I don't. Caroline, if you have a G4, but you're coming to the US for personal reasons and not work reasons, and you're not going to be doing any work, or you're just going to go right back to your home country, then ESTA would be the appropriate option. That is correct. Yeah, it's just the people who, if you're coming to do UN stuff at all, you shouldn't come on any other status than the G4 status. I think I want that one. Yeah, I answered that one. Can your wife apply for a green card if your child is a U.S. citizen and you remain on the G4? Yes. Your spouse can apply for a green card while you the principal remain on G4. As far as you returning to your home country, I don't really understand what that has to do with. Your wife would be a permanent resident, and if you didn't apply for your green card, then you would just depart the country like anyone else. You'd get your repatriation grant and whatnot, and that would be it. Can your 16-year-old daughter have a summer job? I believe we answered that question about getting the work permit, and yes, you will pay taxes on that job. Welcome to adulthood, 16-year-old, paying taxes. So I think I answered that question a few times. That one. I don't know if there's still confusion on this 30 days or 60 days. I thought it was 60 days once you retired or your G4 was canceled, that you had a grace period to stay in the US. But as I said, ultimately, it doesn't really matter. If you leave 1 month, 2 month, 3 months, it's kind of all the same thing. Mercedes, if you want to volunteer at a university, I don't see any problem with that. As far as Caroline's second question about G4, live in any state, I think that there are some countries where you're limited on where you live and how far you go away. I know Russia, for instance, you're not allowed to leave a certain radius of the UN. But otherwise, I don't see any reason why you couldn't live somewhere else. I think that's kind of something you should talk to your own like HR person about. So the N visa. So once the child becomes a citizen, then the N visa no longer works for their family members. It would only be, so the way to work it is you have your N child, your child who became permanent resident, sponsor you for the N visa up until their 21st birthday. Then on their 21st birthday, you would, presumably the child would apply for citizenship, and then as a citizen, sponsor the parents for their own green cards if you wanted. So that would be the way to do it, is keep the child a permanent resident until they're 21. Or if there's a younger sibling that you then get them a green card, then your N can be based on that child while waiting for the older child to become a citizen. And then once the child's a citizen over 21, they can sponsor the parents for their own green cards. There's a lot of questions. I should have had more slides, I guess. Where am I? I lost my place. Oh, here we go. Securing parents. So the kid technically phases questions from 1051. A child has, when they sponsor their parent for a family-based case, they have to fill out an affidavit of support, and so they would supposedly show that they could support their parents, but there are a lot of ways around that. There's the parent's assets. There's potentially the parent's income if it was like the spouse on a work permit. There's joint sponsors. So even if your child like doesn't work or doesn't make enough money, there are still ways to do the affidavit of support for the parents. But from personal experience, your UN pension does not work. I have tried that many times, and USCIS will not consider US pension income for the affidavit of support purposes. Very frustrating. So Hala, how do you calculate 7 years for my children's green card who are G4 visa and still under 21? So you need 7 years between the ages of 5 and the day before your 22nd birthday. So the earliest the child could apply is 12 if they got their G4 status at 5. And then it would just be a cumulative amount of 7 years at that point. So Ali, about the residing in the United States, one of the bullet points showed that you needed 3.5 of the previous 7 years in the US in order to qualify. So you would still need that 3.5 of the 7 years in the US ahead of retirement to qualify and apply for the I-360. Sergio, I'm going to leave that to the accountant. Answer that question. So is it Sally? Is it possible for the spouse who on G4 under their own contract transfer to H1? No. If you're in the same household, then you cannot go to H visa. You would need to remain on a G4 visa. I think I answered Li Wang's question. You can apply for a tourist visa with an approved, pending or approved I-360. Yeah. Elda, I wish I could, but the UN doesn't pay attention to me. I can't make them change their policies or requirements for a job offer. I don't really understand why you need a job offer for the work permit, but yeah, this it's just the way it is. So you filled out your I-360. What should I do next? If you qualify for the benefit, you should send it in with the supporting documents and the money. I think I answered that question. Not going to get into money. So Simona, the best way is your husband's company could sponsor him for a green card through the employment-based first, second, or third preferences. I mean, those aren't necessarily fast options, but that's kind of it. If you were no longer on G4, then there would be potential non-immigrant options for him and you to stay in the U.S., but there's really not a good you can't be on another non-immigrant status while you're on G4. So if I take a post outside the US, but my spouse remains working for the UN, then you'd just become a dependent G4 and you'd be able to travel freely with your dependent G4, even though it's not a principal G4. Is a child born to US parents who are both G4 holders a citizen? Yes. So there is a small subset of people who are born in the United States who are not U.S. citizens. And those are people whose parents have a level of diplomatic immunity that they would be on the blue list. So there's a blue list published like twice a year that lists people who have a high enough level of diplomatic immunity. Generally, that level does not reach G4 people, but instead G1 or A visa holders. And so if you were in a G1 or A visa and you gave birth to a child, technically they would not be a U.S. citizen. They could register for permanent residence at birth. Most people don't know that and then apply for their child to get a passport. And I had a client who was 45 years old, worked for the IRS, and had only left the country twice in their entire life, went to renew their passport and were told that they were not a U.S. citizen because their parent was a diplomat. And you know what? You can't be employed by the IRS if you're not a U.S. citizen. So he then got fired from his job. So that was pretty sad. We went back and registered him as a permanent resident from birth. And so he got a green card that had his birth date on it as his permanent resident date. And the day after he got his green card, we applied for him to become a citizen. And so it was absurdity because he unregistered to vote on Monday, went for his citizenship interview on Tuesday, became a citizen on Tuesday, and then re-registered to vote on Wednesday. It was silly, but this does happen. And I imagine it's going to happen a little bit more frequently going forward because there's a guy at the State Department who apparently, his mission in life is to find these people who were born in diplomatic status and send them these letters that they're not U.S. citizens. And so I would imagine with the new administration that this guy would, be encouraged to do this more. And I've had several clients, and there are really not a lot of people who know this at all. I had one lady reach out to me. She had contacted like 15 immigration lawyers, and they had no idea what she was talking about. There was a woman who, in the news, who joined ISIS, and they found out that her dad was a diplomat, and they went back and looked at the blue list, and he was on it, and they were like, "You can't come back to the U.S. You're not a citizen." So she did not realize that that was a possibility when she left. She's now in some like camp trying to come home to America, but they told her she wasn't a U.S. citizen. So this generally doesn't apply to G4 because G4 people generally don't have that level of diplomatic immunity, but this does come up from time to time. And it is pretty shocking to those people. I'm sorry, Ingeborg, I don't have any information about work when actually employed people. I've never heard of that. I don't know why the U.S. would change their policy or not, but I'm not familiar with that. As Janet, your question about advised by the state department to leave and wait for their home country for the green card conversion. So I'm not sure if you meant the petition or you mean the adjustment of status, or if it's family based or this UN retirement. I think I've covered this though. So I'm going to go to the next one. So Faiza, I think this goes back to the difference between a visa and a status, as far as your question regarding the N visa, whether you can get an N in the United States. So yes, you can only get the N visa outside the United States, but you can change status from G4 to N status from within the United States. You would file I-539 along with an I-566. Donna, to answer your question, if after retirement within 30 days you file I-360 and I-485 through your citizen children, can you legally remain in the U.S.? And will you be out of status? So it wouldn't be the I-360 petition. It would be the I-130 petition. Family-based cases are I-130s. But if you did file I-130 and I-485 through your child, you could and would be legally in the United States for however long it took for that case to process. And you actually couldn't leave the United States until you got advanced parole or your green card. Alice, what kind of proof do you need for 15 years? Personal action report, a letter from the UN stating that you've worked there and you were in G4 status, your P-18 exit interview, personal action reports, letters from your bank, leases, medical records. I mean, there's all kinds of things you can use to show that you are living in the United States. You're going to provide all your passports, visas, and stamps as well. So it all kind of is a cumulative proof that you've been in the U.S. So Fabian, do you have to stay in the U.S. while waiting for your child's petition for you? So the difference is you could immigrant visa process and not adjust status. And if you immigrant visa process, then your child or spouse would file the I-130 petition for you, and you would ask for that case to go through the National Visa Center and then ultimately your home consulate. And as I said, that case would probably take 18 months or more, but that would allow you to continue traveling to the U.S. on your G4 if you were still working, or any other non-immigrant status while waiting for your appointment at your home consulate. So it's not a worse option. It's just a different option. And it just depends on what option makes the most sense for you. So are green card holders allowed to work for another company or own a business besides working for the UN? If you're a green card holder, you could do whatever you want. It would only be up to the UN to decide if they didn't want you to work for another company while working for them. So if your contract with the UN says you can only work for them, then they could fire you for working for someone else. But as far as the US government is concerned, if you're a green card holder, you can work for as many businesses or own as many businesses as you like. Sally, if you're on a G4 and apply for marriage-based green card, you cannot travel on your G4. That's correct. If you leave the United States, while an applicant for adjustment of status without advance parole or your green card, you abandon your application. So they will let you back in the United States on your G4, and then they will send you a nice letter that says your I-485 application has been denied. We're keeping your money. Go ahead and pay us again to do it again. So you certainly could leave, but that's going to cost you $1,440 plus any work or travel permit you paid for. Patel, I think I mentioned this several times. The I-360 by itself gets you nothing. It doesn't get you a work permit. It doesn't get you advanced parole. It just puts you on the waiting list. There's no benefit without filing for adjustment of status, which is only once your turn in line comes. Joyce, I just said, as far as green card holders working for the UN, that there are some positions that could require you to be a G4 visa holder to work for them. This has changed over the years. It used to be very strict that like nobody could be a green card holder. I know more recently I've had lots of clients who remain on working for the UN on a green card. So this is kind of very position specific and something you should talk to your HR about before applying for your green card, whether you're allowed to continue working for them. So Tyne, if your children are U.S. nationals, they could sponsor you, and it's so in the same envelope for a child-based case. So your child sponsors you with the I-130 petition. You file for adjustment of status using I-485, and at the same time, you could apply for advanced parole and a work permit if you want, the affidavit of support. That would all go in one envelope. It's like 100 pages worth of, this is like one of those cases. It's like 100 pages worth of stuff. It all goes in with your medical exam and your photos and everything. So Natalie, can your child come stay with you on ESTA? Sure, your child can come stay with you on ESTA for 90 days, but you can't change status from ESTA. So if you come on ESTA and you want to do a different non-immigrant status, you must leave the United States. The only exception to the ESTA is if you're married to a U.S. citizen or have a U.S. citizen child over 21. Everything else from ESTA, you must leave the United States. That is one of the things you agree to by getting ESTA. So if your son got an internship, they would have to go abroad and come back with like a J1 visa as an intern, for instance. Can one apply for asylum in the U.S. because they can't go back to them? So technically you can apply for asylum, but there are, I don't do asylum cases generally, but there are rules for asylum that you must apply within 6 months of coming to the United States, or if your country conditions change. So that would ultimately could potentially cause you problems. There's also Section 13, which is like diplomat asylum. But there's only like 50 per year of those, and you'd have to have a more specific threat to you. Asylum's actually really hard in that the qualifications are like there's a specific threat from the government. It's not just that your country is in bad shape or has problems. It's more of like the government can't protect you or specifically out to get you. I will, my website is gottfried.net, GOTTFRIED.net, and my email address and phone number are on there. So, Rebecca, your question at 11:06. If you're a permanent resident, then you can continue working for the UN and you could work for anyone else. So I don't know why you would why you would want your G4. But as a permanent resident, you don't have any other status. You're just a permanent resident. And if you enter the United States with your G4 while a permanent resident and not your green card, you could have effectively be considered abandoning your green card, and you'd have to start all over again for that. So that would not be a good idea. So you need your original passport with initial entry in the U.S. As a UN retiree, technically they want all of the passports you've had for the last 15 years. Certainly people lose them. It's not the end of the world. There are other ways to show, and also all of this stuff can be copies. The USCIS no longer requires originals of almost anything except for a medical exam. Everything else can be scanned, copied, printed. Even signatures can be scanned, copied signatures. They don't require original ink signatures or any original documents. They don't even want original documents. So Oliver, as far as taxes go, I think there's this, I don't want to get too much into it, but there's like this substantial presence test of like how much time you spent in the US as a permanent resident versus not in that year. More or less, once you get a green card, you got to start paying taxes. Gabriella, if your child has been a green card holder for 5 years, they can apply for citizenship. So yeah, it's 4 years and 9 months from the date they became a permanent resident. They can apply for citizenship. So Ali, which is faster, U.S. child to sponsor a parent or parent to sponsor a child? A U.S. child sponsoring their parent is an immediate relative, and there's no backlog or wait list. In that case, can happen in like a year. A parent sponsoring their child, if they're under 18, a U.S. citizen parent, child under 18, that's the same. But if the child's like over 21 or married, then there's a backlog, a wait list. I think I answered this question. Can you work for 2 different UN organizations on a G4? I don't see why not. I did have one of your colleagues. He worked like 15 years for one agency, retired, and then did another 15 years for a different agency and retired. Glutton for punishment. Audrey, the I-407 to ban your green card does not affect your new green card. I had a client once, she called me from the LAX airport. She had been outside the U.S. for too long a period of time. They wanted her to give up her green card and come to the U.S. as a tourist. And they kind of talked her into it because really they can't make you give away your green card at the airport. But they talked her into it. And then she called me after they let her go. And then I said, well, your kid's still over 21 and a U.S. citizen, so we'll just apply for you again. And we did, and it was fine. I really think I covered this, Lorraine, but submission to the I-360 does not allow you to stay in the U.S. waiting for your date in line. The I-360 by itself doesn't give you any benefit. As far as Nandini at 11:15 for the affidavit of support, if it's just the child, it would be 125% of poverty. 125% of poverty income for a family of 2 is like $25,000 a year. For a family of 3, it's like $30,000 a year. If you want assets instead of income, it would be 3 times that amount. So for a family of 2, it would be $75,000. For a family of 3, it would be like $90,000. Or you could get a joint sponsor who is anyone who's a permanent resident or citizen who makes that $25,000 a year and shows their pay stub, job letter, tax return. I mean, I had one of your colleagues recently, they had a lifetime pension of 100,000 or more. Their kid was sponsoring them. The kid didn't have a job. The government did not understand the assets we showed for the person. They sent a request for evidence. I explained to my clients that we could fight with them about your assets being well above the requirement, or we could just get your friend to be a joint sponsor. I understand it's absurd, but unfortunately, the people who work in immigration are not the best and brightest. And frankly, you're lucky if they know how to read at all. That's who you're dealing with when it comes to immigration. I think I covered all of this. A DS at 11:20, your fingerprint appointment. Does that mean your green card will be approved? No, but it's just one more step in the process. As far as Zamira's question about disabled child, a disabled child can still sponsor their parent. Yeah, I have actually had many colleagues whose disabled children sponsored them. And even though they have no income, they still can sponsor their parent. I got a nonverbal autistic citizenship. I had someone in a coma become a citizen. So yeah, a disabled child, as long as they're over 21, they could still sponsor their parent, and the child would just make their mark on the form, and would just either use the principal person's assets or joint financial sponsor. Martin's question 1122. If your sibling sponsors you, it doesn't change if you get married. It's only if your parents sponsor you, it changes the waiting list if you get married. I had a client, he sponsored his siblings from Pakistan. He had 5 siblings. 15 years later, it was their turn in line, and 35 of them came over. His siblings, their spouses, and all their kids. Guy runs a restaurant and now has staff for life. Do G4 spouses have the immediate right to work in the U.S.? Same amount as green card holders, they need a work permit. So G4 spouses do need a work permit. I think I covered that. So Omar at 1123, child regarding 7 years. It's up until their 22nd birthday. So it's the day before they turn 22. There's a court case that said you're 21 until you're 22. So it's 364 days. So it's 21 plus 364 days. You could still count that towards the 7 years. I should answer that. 1 year of leave without pay counted towards the 15 years. I don't think the 1 year without leave, without pay would count. I think that would be a interruption of the 15 years, and you would need another 15 years. Sunda, is it few kids who graduate in the U.S. would granted a green card? I think Trump mentioned that once, but there's no way that's going to happen. There's no way. They're going to give less green cards. They're not going to give more green cards with the next administration. That would have to be a law change also. That's not something that could unilaterally be done by the president. So I can't imagine that's going to happen. Can a U.S. citizen sponsor their sibling for a green card? Yes. It just would take many, many years, like 15 years.
David?
Yes.
We are reaching the top of the hour. Can I make a request? Can
Sure.
we capture other questions there share with you and ask you to give us a response, and then I can create a frequently asked questions to provide colleagues.
Sure.
Yeah, is that okay with you?
Sure.
Because we have to wrap up.
I understand.
And I really want to appreciate, thank you so very much for your time today. Very much appreciated. As you can see, all our colleagues showed up.
This is
because
definitely the
very
best turnout
important
I've
topic.
ever seen, for
Yes.
sure.
Colleagues, I would like to remind you, please, that this information provided today was purely on U.S. G4 visa immigration law and its policy. Our HR and internal procedures, it is obvious that from this session that we should explore the opportunity of engaging with our internal partners and have a session similar to this that may answer most of your other internal questions. The union will pursue that. But I hope today was useful for you. It has answered most of your questions. David has been very gracious in giving us this time, and we are very appreciative for it. Thank you, David. Thank
Not
you,
that you all
Ritu.
need to call me like right after we get off this call, but if you call me, I actually do pick up the phone. So
Yes.
you could call me or email me if you had a more specific question. People call me for free advice all the time. So all 400 of you don't need to call me at this moment. I think I'm going to go take a nap, but I am happy to answer questions.
Thank you. I appreciate it. Colleagues, thank you for showing up today. Thank you for your questions. Thank you, Ritu, for holding down the chat and the question and answer forum. I really appreciate
Thank you, Narda. Thank you.
As you see, colleagues, the session was extremely full today, and we appreciate it. Please consider being a dues-paying member of the union so that we can continue working for you, to serve you, and provide you with information that help you make informed decisions. This is the purpose of these sessions. Thank you very much, and I hope that you got a lot from today. The session has been recorded and it will be shared. Thank you again. See you next time. Thank you so much, David.
Thank you, David. Thank you.
Thank you, David. Oh God, let's go. I'm afraid, because of this. Ritu? Ritu's gone. Okay.